So what I would like you to help me, teacher of law, is the legal high standard of fishing expedition. Would you like to stand down that video purely because your witness has confirmed to this Senate and the whole Republic that the governor was not there, her voice was not heard? And if you still stand that you don't want to stand down the evidence, do you want to teach students at the university that they can edify something that lacks moral and intellectual instruction to a council?
Mr. Speaker, I've now found the volume setting the relevant law. It is volume 3 of the County Assembly's document in answer to the question by the Honorable Senator Kalwale at page, I believe, 37 of our Bado volume 3. We have reproduced section 24, page 37 of the Assembly's volume 3. We have produced section 24 of the Public Officer Ethics Act. And it is clear from that section 1, for purposes of compliance with chapter 6, one can take responsibility for acting through others. And in this case, we humbly submit the governor has been acting through her husband. Number 2, this is how, Mr. Speaker, you know the governor was acting through her husband. In October 2022, the husband is seen on the video saying, "These officers shall never return to office, court order or no court order." And true to his utterance, the governor ensures that they don't return for a full 365 days. And while at it, Mr. Speaker, in any event, I keep repeating, there is a conviction as we speak. And that conviction is res judicata. That is to say, that matter is closed as a legal question because it has not been appealed to a higher court within the time required by law. So as we speak right now, the governor is actually a convict. And those are not my words. There is a court order to that effect.
Now, honorable senators, we have 6 more witnesses to call. And if you read the program, we are supposed to stretch it to 7 p.m. And therefore, I will take one clarification from this side and another one here. Most of these clarifications, you'll pick them as we hear the witnesses. Senator Haji Faki.
Mine is to both the council and council for the county assembly and the witness. There were proceedings before the High Court in MERU where the county secretary, according to the judgment and according to the ruling, was found to be guilty of contempt. And the matter is still ongoing. The punishment has not been meted. Now, isn't that subjecting the governor to a double jeopardy? Because he is facing the proceedings before the court in Meru are still alive. And counsel for the governor said earlier that they were actually in court this morning. And here we are, you want us to impeach the governor based on the same set of facts. Isn't this a double jeopardy, which in law is not allowed? Thank you.
Mr. Speaker, that's a legal question. I heard it was addressed to both me and the witness. I don't know whether the witness is able to answer.
Proceed. He belongs to your side. You can answer for him.
First of all, Mr. Speaker, it is not correct to say that the question of whether the governor is guilty of contempt is in court. What is in court is the question of sentencing. The question of liability is settled. The only other thing that is in court is the question of purging the contempt. So there is no question of double jeopardy. As a matter of fact, Mr. Speaker, the rule of double jeopardy does not apply to proceedings of impeachment. There are several rulings by the Supreme Court itself that says, and I can quote the Sonko case, the Martin Nyaga-Wambora case, that say impeachment is not about civil or criminal liability. It is about political accountability. It is about ethics. It is about the type of leadership, the type of persons we want holding certain offices. And that is why you find the Article 181 is about may be removed on any of the following, and it talks of gross misconduct. Gross misconduct need not even be a criminal or civil offense. It can be anything that attracts serious moral censure. It talks of gross violation of the Constitution or other law. And in short, all we are saying, the Supreme Court has already answered this question of double jeopardy. And that is why even the Court of Appeal itself and the High Court in MERU, guided by the Supreme Court, refused to stop this Senate from sitting on these charges and making it whatever decision it will make, because the courts have already confirmed it is not about legalese and splitting legal heirs or civil or criminal liability. It's a question whether the governor accused of the things we are accusing her and which will prove is the type of governor we want to see holding a public office within the meaning of Chapter 6 of our Constitution. It is not a legal matter, Mr. Speaker. And I'm lastly told, if this can be let to happen, then all I need to always avoid impeachment, which is actually what the governor tried to do at the High Court and the Court of Appeal, why she failed. All I need to ensure as a governor, if this were unanswered, to ensure Article 81 is dead, is to ensure whenever I commit a breach of the Constitution, there is a court case like happened in this matter, where proxies were obtained to file various suits in court so that they can come under the pretext. And even in your own standing orders, Mr. Speaker, as well as those of the County Assembly, you will note the mere fact that a matter is in court does not stop the Senate or even the National Assembly. You can even take notice, Mr. Speaker, that as we speak, there has been a matter in Shakahola, which is in various courts, criminal courts, and I've seen committees of parliament examining the same persons who are facing not just employment courts here, but actually criminal courts, and nothing has stopped either the Senate or the National Assembly. And that is why even your standing orders give the Speaker the latitude to decide whether a matter that is in court should nonetheless be deliberated upon and a decision made by Parliament, in this case the Senate, as the representative of the public conscience.
Lastly, Senator Veronica.
Thank you, Mr. Speaker. Just a clarification from the Council for the County Assembly of MERU. We have seen this judgment, is it a ruling, the one that you are relying on the contempt proceedings? And 37C on page, I think you know where it is. 37C talks about the respondents not having the audience of the court until the contempt is purged. I think the witness has confirmed that he's now being paid They have been reinstated, or did I get it wrong? I hope that's a correct position. Council, do you treat that as a purge to that contempt? Now that that is no longer, those offenses are no longer taking place and they have been reinstated, would you treat that as a purge? And I know that the sentencing is awaiting before the court. And if the sentencing is awaiting, would you still say the matter is not pending before court?
Mr. Speaker, then being denied audience is part of the standard rules that govern contempt of court. If you're convicted, like the governor has been, you're denied audience until you purge the contempt. The governor has, of course, attempted to purge this contempt as we speak. I use the word attempted because the witness told you the letters appointing his replacements have not been recalled. They have not been rescinded, so that as we speak, we have the witness here and his 3 colleagues who are the substantive office holders, and then we have the other persons who are also in acting capacity. The purging of a contempt, Mr. Speaker, is something in the realm of mitigation of sentence. That's why you're denied audience until you purge it. So the fact that someone has purged the contempt does not undo the conviction. The conviction still remains, and as we speak, even if she purges and apologizes and recites whatever prayer about it, it will always remain the record of the court that she was convicted and that conviction has not been set aside.
And this witness at that. Now, as we prepare to usher in the second witness, pursuant to Rules 23 of our third schedule of the Standing Orders of the Senate, as a speaker, I do not have that latitude to ask for any clarification or ask questions. However, if the integrity of the institution of the Senate is at stake, then as a speaker, I need to guard it. Counsel for the County Assembly, your allegory, the Russian allegory, that when the man was asked to say something, he said Russia don't know how to do things, and that's why he was alive. That statement, in its ordinary meaning, could be understood, and indeed it was understood, and that's why Senator Mungatana rose to ask that question. It was understood to mean that the Senate did not do a good job in the first impeachment. I don't know, Counsel for the County Assembly, whether you still want to have that allegory as part of your record, or at this juncture, you want to take it away from the record.
Mr. Speaker, my allegory was not a slur on the Senate. It was, as I said, about a person who was lucky to escape a certain fate, and instead of refraining from utterances that had placed him in that fate, continues doing it after the rope breaks. And I was clear in my allegory that even in Russia, this was understood to be an act of providence, that the man in question was lucky. It is our submission that if the governor, KAWIRA, was lucky to be acquitted of certain allegations, the least anyone would expect of her is to refrain from the behavior. So I didn't mean in any way to slur the Senate. In the event that I am misunderstood as criticizing the Senate's decision, then I offer an unqualified apology, and I'll be open to even the expansion of the relevant allegory. And since it seems to cause the too many issues. I seem to have been misunderstood. Mr. Speaker, I beg that it be expunged.
Kindly usher in the second witness.